And so it's a great pleasure to frame the conversation that way. And to kick it off, we have an absolute wonderful first panel, and it's my pleasure to introduce Morgan Whitlatch, who's the legal director of the Quality Trust for Individuals with Disabilities, for the first panel today.
Thank you so much, Gina. My name is Morgan Whitlatch. I'm the legal director of Quality Trust for Individuals with Disabilities, and I'm really excited to be moderating this panel today and joined by such distinguished experts in the field. As Gina indicated, our focus is on restoring rights, moving beyond guardianship, and it couldn't be more apropos. Recently we've seen these topics that we're going to be talking about today covered in the popular press after a really high-profile public figure, Britney Spears, shared her personal experience living under a conservatorship. And her story has shined a national spotlight on many of the problems of guardianship and conservatorship systems. We all should know that Ms. Spears is not alone. For years, many of us have been fighting within the disability justice community to advocate for alternatives to overbroad, restrictive, and undue guardianship. And I'm really looking forward to today's conversation furthering that discussion. In a time when the focus of disability policy and services is to advance the self-determination and rights of people with disabilities, guardianship remains a pervasive aspect of the United States legal system, and it's frequently treated as the default option, particularly for adults with intellectual and developmental disabilities. Though the specific procedures vary by state, guardianship or conservatorship's the process by which a court makes a finding that a person lacks capacity to make certain decisions and appoints a third party to make it for the person. While the scope of guardianship or conservatorship is dependent on the particular court order and state law, in all cases we have to realize that it results in a loss of personal autonomy, as people subject to it are no longer able or recognized as having the legal right to direct their own lives. Yet we are seeing in the United States important strides that are being made to shift the culture away from the substitute or surrogate decision-making models for people with disabilities and towards approaches like supported decision-making, which you're going to be hearing more about today. We're seeing the promotion of reforms that are designed to make the due process protections that should be embedded in legal systems a reality in the lives of people with disabilities. For example, at the 4th National Guardianship Summit in May this year, that resulted in some really important recommendations. This panel is going to be exploring strategies for continuing the movement beyond guardianship, and it's going to be informed by a really vibrant combination of personal, familial, legal, and other professional perspectives, which is why I'm so excited to be here today. And I would like to introduce our wonderful panelists for today's discussion. I'm going to ask our panelists to turn their cameras on. We have Deborah Dorfman, who is the Executive Director of Disability Rights Connecticut. We also have Michael Kendrick, who's the Director of Initiatives on Supported Decision-Making at the Center for Public Representation. We have Ryan King, who's a disability rights advocate in DC, and his mother, Susie King, who's a parent advocate. Ryan and his family's story was highlighted this weekend. I hope you saw it in the New York Times article that discussed his journey in becoming the first DC resident to have his rights restored in favor of supported decision-making. So thank you all for joining us. We're going to get underway, and we'll begin our discussion with Debbie Dorfman.
Thank you so much, and thank you all for having me here today. I'm really excited and particularly excited to talk about supported decision-making. I've been doing advocacy on behalf of people with disabilities in the context of supported decision-making for the last several years. Most recently, I just recently started as Connecticut's executive director for the P&A, but before that, I was working for the Northwest Justice Project, where I was representing individuals with disabilities and also family members, and doing advocacy to try to move people away from guardianship and into thinking about guardianship alternatives such as supported decision-making. And so today I'd just like to begin by just talking about supported decision-making as a guardianship alternative from sort of a legal rights context, and then share with you one of the cases that I did when I was at the Northwest Justice Project that involved actually preserving rights and avoiding a guardianship altogether. So to start out with, probably you are all familiar with supported decision-making, but just to make sure that everyone understands what that concept is that supported decision-making agreement is a way that individuals with disabilities can receive support from people who they choose on issues and for decisions that they decide they want help with, in a way that they think is helpful to them. And so it's really a way to help not only make decisions, but also communicate those decisions to third parties and to help think through alternatives and that sort of thing. But it, at the same time, make sure that the process recognizes the individual's autonomy, which is really crucial in making sure that people's rights to decision-making and legal capacity and autonomy are being recognized and being enforced. And so it really puts the control of the process in the hands of the person who, for whom the supported decision-making agreement has been created. And it's a wonderful alternative to a guardianship that can really help somebody without all of the restrictions of a guardianship. Unfortunately, while there has been a lot of progress made, there's a lot of people who've never heard of supported decision-making in your everyday life. For example, supported decision-making might be really useful for a person to make financial decisions or decisions about healthcare or decisions about even personal relationships. But you know, the average banker, for example, probably doesn't know about supported decision-making, or the average healthcare provider probably doesn't know. So education is really, really key. And this also goes to educating judges and other individuals who are in the world of sort of the guardianship process, so that people can actually use supported decision-making as an alternative to guardianship, and not only have guardianships removed, but also stopping them from being imposed in the first place. And I just wanted to share with you a case that I did in Snohomish County, Washington, which is just a little bit north of Seattle, where I worked with, I actually represented the mother of an individual who I was representing her on some other matters, and her son, who was in his early 20s, had an intellectual disability, started to unfortunately have some legal problems, and they stemmed from a relationship that went poorly with one of his friends. And so she became worried, and on her own, before retaining me on the guardianship issue, decided to file a petition for guardianship because she was worried about what would happen to her son given the legal problems that he was encountering. And so as is often the case, and when a guardianship petition is filed, is that a guardian ad litem, or somebody in Washington State, it's now called a court visitor, but someone like that basically is appointed by the court to investigate whether or not that person believes that the individual for whom the petition was filed needs a guardianship. And so in this case, there was a guardian ad litem appointed, and that person had finished his investigation prior to me getting involved in the case, and had made a decision that the individual, the young man, needed a full guardianship, and not even just a limited guardianship, but actually a full guardianship. But yet, that actually wasn't even what his mother really had intended to start with. So, but by then, because the petition had been filed, things were in motion. And once the petition gets filed, you know, the power sort of leaves the individuals and gets into the hands of the court to make decisions. And also, the mother and the young man were unaware of supported decision-making, had never heard of it before. And so once I was retained, I discussed supported decision-making with the mother, and also we were able to get counsel for the young man because he didn't have any counsel. And the P&A was counsel for the young man, and we worked together because the family, both the young man and the mother, once they found out about supported decision-making, realized that's really what they wanted, and that a guardianship was not necessary. And they were really excited about a supported decision-making agreement. And so while we wished that we could just have the mother withdraw the petition and then, go on their merry way with their supported decision-making agreement, it wasn't so simple. And that was because, as I mentioned earlier, once a guardianship petition gets into the hands of the court, it's pretty much the case that that's really then up to the court to decide whether a guardianship will be appointed, and not that the parties just can't say, oh, we changed our mind. It's not so simple, because the court now has a responsibility to make a decision. And in order to try to stop this process and to stop the guardianship from being appointed, and this was really important because getting in at the beginning, this is all a lesson of getting in the beginning is really important, because once a guardianship gets established, it's very difficult to have it removed. It's much harder to have it removed than to stop it at the beginning. So that's an advocacy tip for everybody who's trying to use supported decision-making as a guardianship alternative. So we ended up, because the process had already started, but the guardianship hadn't been appointed, we decided that we needed to first educate the guardian ad litem, because he'd already written this report saying that the young man needed the full guardianship. So in order to really change the situation and be able to convince the court to not appoint the guardianship, the key person, the first person to talk to was the guardian ad litem, to try to convince him to change his mind. And so the P&A lawyer and me met with the guardian ad litem, and we provided him with some very, a number of really key documents that explained what supported decision-making is, and also explained how it worked, and also importantly pointed out that supported decision-making was being used elsewhere. Now, at this time, Washington did not have a supported decision-making statute. It does now. It hasn't actually gone into effect, but at the time it didn't. It was just about a year before the statute was passed, or about 6 months before it was passed. But there was no statute, and that's okay. You can still do advocacy. You can still have a supported decision-making agreement without a statute. So that shouldn't be a barrier. While it's helpful to have, it's not required. And so we provided all of this information to the guardian ad litem. We also, another thing that was really helpful was information about the American Bar Association and their endorsement of supported decision-making. That carried a lot of weight with the GAL, so I would highly recommend that. We also provided references and gave the website links to the Quality Trust's supporteddecisionmaking.org, which is incredibly helpful, and asked that the GAL review that, along with the Center for Public Representation's website as well, which is also extremely helpful. And he did that, and after reviewing all the materials and talking with us and reviewing the supported decision-making agreement that the family had entered into, decided that he agreed and was really excited about that, and joined us actually in seeking a dismissal of the guardianship with the judge, which was pretty amazing. So here we had the petitioner's counsel, the counsel representing the young man, and the GAL all signing on to papers asking the court to dismiss the guardianship, which is pretty unusual, but was very effective. One thing we also did, because we wanted to make sure that the judge understood, even though we had the GAL sign off, and that was tremendous, we wanted to also make sure that the judge had plenty of information, and it was in the record, in the court record, in case anybody later questioned it, why supported decision-making would be appropriate in this situation, how it would work. And so what we did is we created something called an advisory, which we filed with the court, and it was a joint advisory signed by the young man's attorney from the P&A, me, and the GAL. And in it, we detailed specific information about the young man and why he didn't, why the legal standard wasn't met for him to need a guardian. But we also, importantly, put a lot of information about supported decision-making in the advisory, and provided the court with also an article about how judges can use supported decision-making. We also, like with the GAL, provided key documents of the American Bar Association's endorsement. We also provided references to the Quality Trust's website and the Center for Public Representation's website and other information, and explained supported decision-making so that the court, by the time we had the hearing, the court completely understood what we were talking about. And actually, the judge had very few questions and quickly granted the dismissal of the supported decision-making agreement. And I'm really pleased to say that since that time, the supported decision-making agreement has worked really well for the young man and his family. He's really pleased with it, and nobody's thinking about guardianship anymore. So that's just a case example, but it's a way in which you can use supported decision-making as an advocacy tool to actually stop a guardianship from happening. And again, I just have to emphasize that the sooner you can get in on the advocacy, the better. So to stop the wheels of the guardianship process turning. And I know that I'm short on time, so I will stop now and turn it back over to Morgan. So thank you.
Thank you so much, Debbie. I think that was a really great kind of concrete description of how supported decision-making can be used to divert guardianship. So thank you very much. We're now going to turn over to Michael Kendrick to talk more about supported decision-making in practice. Michael?
Thank you. The supported decision-making as practice is really something that's still in development in many places. It's very hard to say exactly what things are going to look like in 20, 25 years from now, because the more people that are involved with the practice of supported decision-making, I think the more we'll see innovations and developments that aren't currently on the scene. And at this point, supported decision-making is relatively new to a lot of people, even though the actual practice of supported decision-making is actually quite familiar, because people are getting support with their decisions down through the centuries. We just didn't have a name for it, such as supported decision-making, but it certainly was effective 10 centuries ago, and it's going to be effective today, because support with decisions does make a difference. And not having support with decisions also has its own sort of impacts. Now, the merits of supported decision-making then need to be appreciated a little bit, and that is seen in some ways in the terms of it being an alternative to guardianship. And of course, the great merit of supported decision-making is that you get to be the decision maker. If you're under guardianship, you stop being the decision maker and someone else is making decisions for you. So supported decision-making as an option really prevents the loss of the right to make your own decisions. And of course, the practice of supported decision-making is now being, if you like, marketed or sold or persuaded by the idea that it is an alternative to guardianship, and that there is no need for guardianship if you're getting support with your decisions. And it's also seen today as a practice where it is the place to start, not where you end up. That you start with supported decision-making rather than start with guardianship. Because for many people, that's what is the first thing that happens to them, is they're placed under guardianship, when in fact there are alternatives such as supported decision-making that should have been looked at and exhausted before one even thought about guardianship. But it isn't that it's just that it's an alternative to guardianship. It has other benefits that need to be appreciated. One is that it is a way to ensure better outcomes for the person in terms of decisions. If you're getting support with your decisions, you're more likely to do better with your life and with whatever those decisions entail. People that don't have support with their decisions are more vulnerable to making poor decisions. So support decision-making then is a kind of an intentional safeguard to help people manage a very important task in life, which is making decisions. Now, support decision-making isn't something that you just do on its own. You can combine it with other supports, such as healthcare proxies, durable power of attorney, representative payee arrangements. So these other vehicles for support can also be present, but the support decision-making still leaves people in the driver's seat in terms of making their own decisions. Now, there are some formalities. Deborah and Morgan both referenced the possibility that there could be support decision-making agreements if there is a statute that recognizes them, but you can also have support decision-making agreements without a statute, as Deborah had pointed out. And but the formal aspect of support decision-making is often represented by the support decision-making agreement, which identifies essentially who you're asking to support you with your decisions and in which area of life you're seeking their support. But of course, it isn't necessary to put all that into an agreement because there could be people you turn to only occasionally as a supporter on decisions. So in this sense, the formal practice of a support decision-making agreement may not always be needed for day-to-day support with decisions. In this way, it's important to recognize that most people make their decisions quite informally. If we had to make every decision a formal decision, I don't think we would want to get up in the mornings. But if you just think of decision-making as something that's done informally, even though it's very important, it is done informally, then you get a better feel for how actually support decision-making would work. Now, a notable aspect of support decision-making practice is that it's highly person-centered. In other words, every person that makes decisions makes them in their own way. So it's very important to see that the personhood of people is linked and should be linked to the practice of support decision-making, because people want to make their decisions in a way that is comfortable to them making their decisions. And everyone goes about decision-making a little bit different from the way somebody else might. And so in this sense, it merges very well with the idea of person-centered practice, which has been so significant in a broader sense in the disability community as well as in other areas. So it's very important to see that the person-centered thinking applies highly to decision-making and to supported decision-making. Now, it isn't that you make decisions in the same way now as you will 10 years from now. In other words, decision-making is a process that you can evolve in. And so supported decision-making isn't just about the decisions you make early on. It may be how you move from how you made decisions 10 years ago to where you'll be in another 10 years in terms of your approach to decision-making can evolve over time depending on what you learn, what your needs are, and so on. And so people can learn from decision-making. And if you don't learn from decision-making, you might be missing an opportunity because some of our decisions aren't that good. So it'd be good that we learn from the decisions that weren't that good. Now, in this sense, there could be changes that people develop over time because of their practice of supported decision-making. And in this way, that people shift how they go about making decisions based on the influence of the support they're getting and what lessons they're drawing from that support. So in this sense, it's an active process of reconsidering how you go about making decisions rather than locking you into a particular pattern. It is really the exploration of decision-making that we need to see as an ongoing kind of challenge. Now, many people think of support decision-making as a safeguard in terms of persons' vulnerabilities. And it does serve that purpose, that when you're getting support with your decisions, your vulnerabilities may be less complicating than they might be if you didn't have that support. And that's true for all of us when we get support and when we don't. But it doesn't make, support decision-making doesn't make vulnerability go away. We still stay vulnerable no matter what kind of support we're getting. But the vulnerabilities are better managed when you have support. So when people are isolated, it makes them more vulnerable. When they have support with an important activity like decision-making, that actually helps them manage their vulnerability in new and important ways. We shouldn't make the claim that supported decision-making means that you'll always make good decisions. If that were the case, you would be perfect. But for imperfect people, you can pretty much bet on the fact you're going to make some poor decisions. And in this sense, the support decision-making isn't a foolproof safeguard that people are just going to suddenly become spontaneously outstanding at decision-making. But they could be better at decision-making if they're getting support through supported decision-making. And over time, that can make a difference. That over time, people can accumulate competencies and skills and attitudes that end up benefiting the quality of the decisions they're making. And of course, what this means is that support decision-making is exploring decision-making and learning different aspects of decision-making as you explore decision-making in different areas of your life. And of course, for all of us, then it also means recognizing the pitfalls and the hazards that are present in decision-making and figuring out how to manage those potential consequences. So in this sense, that's not a lesson you learn once or twice, but rather one that you revisit over time. And so people may struggle with decision-making. Nonetheless, they may still be getting better at it because of the support that they've got. And a very good example of this is even becoming better at knowing when it's time to seek support with a particular decision, because you begin to recognize, well, this is something I really need to think about, so I'll talk to one of my supporters about this particular thing. So even the recognition that a difficult decision is in front of you could be a learned outcome of practicing supported decision-making. So it's good with supported decision-making as practice to think of it as a developmental process where you're growing and developing over time. So in this sense, you could take a snapshot at any point in time and have a lot of strengths and weaknesses around your decision-making. But if you took a snapshot a few years later, that pattern may have changed because of what you've learned over those years of practicing making your decisions. So in this way, one can think of supported decision-making as an ongoing kind of growth opportunity, a developmental opportunity, but it can also be seen as a set of safeguards to your decision-making that continue to evolve with you and with your life. Because just one aspect of this would be you may turn to new types of supporters because of the new conditions in your life. You may start looking at some other decisions you hadn't really spent a lot of time on before because of changes in your life and the recognition that, well, I might need a bit of different support on this issue because I don't know much about this kind of decision making, or whatever it might be. So in this way, the pattern of practice that I've been talking about evolves with people in terms of what their life circumstances are, what they're having to contend with, and the finding ways to manage that over time. And again, so we shouldn't think of support decision-making as a kind of scripted way to go about decision-making, but rather as an evolving way that people learn to manage whatever their life circumstances are. And as life circumstances and challenges change, how you make your decisions ought to change as well. So in this sense, you could think of support decision-making as an adaptive practice that enables people to, no matter what they now have to face in their life, to develop a pattern of decision-making that will work for them. Thank you.
You know, Michael, one of the questions I frequently get about like supported decision-making and trying to, for example, persuade guardian ad litems or persuade courts about it is concerns about supporters engaging in like undue influence or that kind of vulnerability or having certain kinds of conflicts of interest among supporters. If, for example, like supporters are paid staff or have that kind of role. And I know that CPR has been involved in a number of pilots that have had to kind of explore those kinds of issues that can come up. Could you kind of provide some kind of concrete tips for the audience on addressing those kinds of concerns?
Well, this is a concern because no matter who is supporting you, they aren't going to be 100% good at it. They may have their own conflicts. They may not manage every action of support well, and so on. So there is reason to be concerned. However, it's also true that you can't get perfect people to support you. And in this sense, if you want perfect people to support you, I don't know where you can find them. And no matter, so if you want people that are just human beings that are doing their best to be supportive, you have lots of those people. If you want perfect people, you may have to wait, kind of indefinitely. So in this sense, yes, any supporter will potentially bring their own conflicts or their own issues to the table. But we can't do it with perfect people because there's such a small sample available of perfect people. So if you want to do supported decision-making, you've got to kind of put up with imperfect people.
Thank you so much, Michael. So now we're going to turn over to Ryan King and his mother, Susie King, to talk about their experience. So take it away, Ryan and Susie.
Thank you.
Okay.
Introduce yourself.
My name is Ryan King. I'm 38 years old. I live in Washington, D.C. I'm no longer need guardianship. And that's it.
That's it. But you find yourself being very independent?
Yes.
Have you always been taught to be independent?
Yes.
Yes, that's right. Ron and I'd like to share our story about how we got under guardianship as he exited the DC public school system and moving to the next level. The idea was that you wanted to start your what?
Home business.
Yeah, he wanted to sell CDs on eBay, and eBay was new to us. And we figured out we needed help with the government agency. And we went to the government agency that was providing the services that would support us. And when we got there, we were told as a family that we had to get guardianship. We questioned that. We were reluctant, but we did because we knew that Ryan was entitled to these services that we were trying to seek. And as we move forward, we question it, but we've always been supportive of you, and we've always encouraged you to do what?
Be independent.
Yeah, make your what?
Own decisions.
Yeah, make your own decisions and choices, right. When we went to the courts, Ryan was always assigned a lawyer.
Yes.
And we filled out lots of paperwork, but we were still uncomfortable with the whole idea of him being guardianship because we already had a network of family members and friends, right?
Yes.
Right. We have because you have what? Which one of the
Sickle
things?
cell.
Yeah, were you hospitalized a lot?
That was when I was young.
Yeah, when you were younger, you were hospitalized an awful lot. So we always had to have someone be with him 24 hours. So we depended on family members and friends that were really close and supporting us at all times. So when we ventured into the whole guardianship process and got involved with the court system, we realized that every 6 months, what do we have to do? You remember?
Report to the court.
Yeah, do you remember some of the things we had to report?
Oh, that was a lot of paperwork.
There was a lot of paperwork, but we had to report what?
Oh, we had to report our money.
Your money, right? Because we got conservatorship.
We
Doctor
doctors
visits. What?
visits and
Do you like to go where?
WWE.
Yeah, WWE wrestling events. What about
And we had to report on
movies?
Movies
Love
as well.
movies. Yeah, movies, concerts.
yeah.
All of those things we had to report about every 6 months to the court.
Mhm.
We not only got guardianship, but we got conservatorship because Ryan's been working since when?
Since 2000. Even this was before I met Quality Trust.
Right.
I already had a job, so I feel like I didn't need guardianship because I've been independent all my life.
Right, very independent. We all need what?
Hope.
Yeah, we all need support and help at some point. But because Ryan was working, we also got conservatorship. Well, back in 2007, my husband and I went back to the court system to do an appeal. And at that time, were you assigned a lawyer?
Yes.
And what happened? The lawyer came where?
The lawyer came out for 2 hours.
Yeah, any of the lawyers that basically came out for whatever reason, they spent no more than 2 hours. Ron was not only working at that time, but he was also, what were you doing at that time too? You were working and you were?
Going to school.
No, you were volunteering.
Volunteering
Yeah.
at that time.
And you volunteered for how many years?
12.
That's right. He was at a volunteer program as a day program in the District of Columbia. So he was really involved, but anytime a lawyer came out that was assigned to the courts to support Ryan, they never went beyond our living room. So our concern was that they really weren't getting to know him and all that he was involved and could do. So we did our appeal in 2007, but of course we lost. And a lawyer that was assigned to Ryan terminated what? What was terminated?
Guardianship.
Not guardianship.
No, not guardianship, but
they added what?
They added you, Aaron, Dad.
That's right. And Aaron is who?
My sister.
Aaron is his sister. They added his sister to the guardianship, but terminated the conservatorship because the appointed lawyer said Ryan still needed to be in the guardianship. Yet he went not beyond our home to see how he interacted, how he caught the disability services, transportation service by himself, how you have your own security
code
to get
in and out.
To get in and out of the home. And Ryan can prepare what? What can you do? You prepare your what?
On meals.
Yeah, you can prepare meals. What about your laundry?
Yes, I can do my laundry. I can do all that.
Right, but no one, it's to see how he actually functioned. So since we lost the court case, we followed the Jenny Hatch story.
Mm-hmm.
And after we read it, and I said to Ryan, what do you think about that? What'd you say to me?
I said, I can do that.
I can do that. He told me I can do that. So what did we do?
So we went back to the court.
No, we didn't go back to the court.
No,
We reached out to who?
We reached out to Quality Trust.
Right, and we were assigned lawyers that came and they worked with us for at least
2.5 hours. Minutes.
Years. Yeah.
Where did I get this?
I don't know. But anyway, it took us that long to develop a packet that Ryan would be comfortable with, that showed who he was, what he could do. And not only did the package included a psychological evaluation, and it wasn't based on his IQ, but it was based on what?
How how I function.
That's right, how you function. And that psychologist came out and spent a whole day with you, and he went to
Yeah.
where?
My job site,
Came to what?
came to the home,
And where did you go after?
and
You went where?
went to the bank
Yes, he wanted to see how you what?
function.
Right. He wanted to see how Ryan functioned. And as a result of that, he developed an evaluation, a functionality evaluation, not based on his IQ, but based on what he could do in everyday living skills. So after the packet was developed, we went back where? After the packet was developed,
We went back to the court.
went back to the courts. And at that time, we wanted to see using supportive decision-making, because we became very involved with Quality Trust, as Ryan said. And we started attending seminars that they were presenting, workshops, so we as a family could learn about supportive decision-making, since it was a very new concept.
Yes.
That's right. And we got on board. They worked with Ryan for 2.5 years. They wanted to make sure that he understood. They wanted to get to know who Ryan was, things that he could do and things he what?
Can't do.
Right, that's right. And Ryan had a lot of input in the whole process. We looked at Ryan as a whole person. We looked at everybody that was in your what?
Circle.
And your circle, that's right. We wanted to see everybody that was involved with Ryan, from our neighbors to his staff persons that were involved in, like you said, you've been working at Safeway for how many years?
This year makes 21.
This year makes 21 years. So they knew him well as a worker and everything. So they were very supportive and have been supportive of him. If there's ever an issue with the transportation service that they use, someone's there to make sure that he can reach us as a family member to deal with the issue. But when we got to court, we had a very large what?
Packet.
We had a very large packet, that's right. And when the judge started talking, what did the judge tell you? He had what? Read
the whole packet.
He had read the whole packet, and it was a big packet. And he determined at that time that what? The judge said you what?
No longer need guardianship.
You no longer needed guardianship. How did that make you feel?
Feel great.
Feel great, yeah, right. Now, did we have to report any more to the courts?
No.
Did we have to have any lawyers come visit us at our home?
No.
No, you are now doing everything that the family was doing, right? Without having to what?
Oh.
Without
reporting to the court.
Yeah, that's right. You didn't have to talk about going to concerts or church or doctor's appointments, anything that you were involved in. So
especially we didn't have to talk about the money.
Yeah, you didn't have to talk about your money. Very concerned about his money, very concerned about his money. But as a result of that, we also developed something else. Do you remember what that's called?
Power of attorney.
Power of attorney. We developed, not only did we do the packet for the courts with using supportive decision-making process, like you said, we also developed a power of attorney. Do you know what that means?
Yeah, if I become incapacitated.
What happens? If you become incapacitated.
If I can't make my own decisions.
That's right. With help, then who's going to help you make those decisions? Who did you decide you wanted to be involved with that?
You, Aaron.
You,
Aaron, and Dad.
That's right. Those are the family members. We make up the team.
Yeah.
And so we put that in place, but a lot of time was spent on making sure that Ryan understood what incapacitated meant, what would happen before we presented that to the court as well. So we spent an awful lot of time making sure that he was comfortable with the process, what was going on, make sure that he understood, and that we knew that he always had been taught and supported and had a good pool of people around him and to support him. So we've discovered that when you get guardianship, it's not a one shoe that fits all. You really have to get to know the individual. You really have to know what that person's capabilities is and is not, to really learn who they are as a person. And we felt that the court never got to know who Ryan was as a person. And so that's why when we did the packet, we were inclusive of all of his individual service plans, from his service coordinator that works with him, making sure he's getting his goals set and all of that. We had a one-time visit by the court monitor, made sure her report was very positive when she reached out to us and reached out to Ryan. We wanted to put all factors in to make sure that the court understand who Ryan was and how you could
Function.
and how you could function. That's right. So when you look at an individual with disabilities, please don't look at them for the disability, but look at them as a whole human being person, what they can and cannot do. And if there's anything you want to tell everybody, what would you say to them?
You know.
No, you know.
Don't judge me before you get to know me.
Don't judge me before you get to know me. Because no, come back. See, not finishing. Okay, bye-bye. He's gone. He's gone. He's a little nervous. He did well considering the nerves. He was jittery. But that's how we got to where we are. We really depended on Quality Trust for helping us and guiding us, for showing that we, as parents, knew our child, knew what his capabilities are, and how we had to just fight with the system. It's been lots of barriers to cross, lots of challenges to deal with, but we overcame it, and he's a happy camper, as I would say. And now he's out advocating for persons with disabilities, not only for himself, but for others. And he's gotten really involved with other organizations, to include Quality Trust as a board member now. He's a member of Lifeline Partnership, which is a spiritual and supportive organization, as a board member. And he's with another organization, Project Action. He's a board member, and also he holds a position as co-sergeant at arms. So he's really been always active, but this is really helping to guide him to become even a stronger person. And we'd like to really thank you for listening to our story and how we got to where we are today. Thank you.
Thank you so much, Susie and Ryan. I always get a real kick when I hear your story from your perspective of it. You know, when I think about Quality Trust helping you through that process, I think about some of the kind of legal barriers that you all faced when you back in 2007, when you actually you went in with 2 guardians to try. Ryan went in with 2 guardians to try to get them removed, and left with 3 guardians, right? Right. And I think about some of the what is that? What is that barrier that kind of created that dynamic back in 2007? And one of them really is, you know, he had a court-appointed attorney. I mean, there are really strong due process protections in DC on the books. He was appointed an attorney, yet you said that his own attorney said he needed a guardian, even though that's not what Ryan wanted. You know, and for me, I think that's a lesson of zealous advocacy on behalf of your client, a testament to all the attorneys that are out there to say, you're actually supposed to be advocating for your client's express wishes there. So that's one thing I just really wanted to pick out of your story to really be highlighting for people, because I think that's really key. If you had, you know, in thinking about, you know, the journey that you and Ryan had together, and supporting him and getting him to a point where the guardianship was terminated, is there something that you would, you know, suggest, a key takeaway that, you know, parents or families hear about your journey in terms of, you know, getting ultimate guardianship but then terminating the guardianship? Is there a takeaway you would want them to hear?
I would want them to take away that we always looked at our son as a whole person, as a human being, what he could and could not do. And we wanted to make sure that we educated anybody that entered his life about what he could and could not do. And from there, we wanted to make sure that we always respected what he wanted. No matter what he wants, we put forth an effort to try it. He wanted to do, like I said, he wanted to sell the CDs. We followed that. He got involved with training programs to be an entrepreneur. He changed from that, wanted to do the limousine business. We followed him through that and everything. But getting to know your child, know that what you want for your child and what your child wants, and just really sticking with it. It's not easy, it's not hard, but on the end, it's the most rewarding thing. So just really stick with it if you believe that's the best fit for your child.
Thank you so much. So we've gotten some questions. We've entered our Q&A portion of this panel. And so I encourage people to type in their questions into the chat box or the Q&A box. So first we got a question from Julie. Can Michael talk about conflicts of interest when a provider facilitates supported decision-making? Is there any oversight?
Well, typically, conflicts of interest are very real and very problematic, particularly when people don't recognize that they have them. So it's often very helpful to essentially to have people that are willing to name the conflict of interest and to address, why it is problematic in terms of its consequences. So having some kind of consciousness about it, about what a conflict of interest is and why it's problematic is sort of a starting point for managing the fact that these things do arise and cause a lot of mischief and agendas that are not very helpful. I think one of the worst things that can be done is not to engage the conflict of interest and to pretend it isn't a problem when in fact it is a problem. And it's in a project that's supporting supported decision making. That project needs to essentially have some means by which they routinely engage on the question of what the conflict of interest is, even if some individuals aren't very good themselves at addressing it. Somebody ultimately should be addressing it, and it isn't always the same person in each situation, but it should be addressed and collectively if it can't be addressed, individually.
I also always think, when I think about the safeguards that you incorporate within supported decision-making, the acknowledgement that conflicts of interest do exist, like you say, and using a team approach to try to be identifying and addressing those conflicts, I think were some key takeaways from what you said, Michael. Another question from Allison, and this is to Susie and Ryan. Can we get more information about the POA? Do you include guidance within the POA regarding when and how it will trigger? How the POA makes decisions, or how the agent makes decisions when that POA is triggered, perhaps to include input from Ryan as much as possible. So I know you both worked on that power of attorney with Quality Trust, and I'm very familiar with what was in it. I think Ryan did touch upon it triggered on incapacity, right? Were there other kinds of protections within that document?
This particular power of attorney was for help. And we were really concerned because of the sickle cell disease that Ryan does have, that we focused on that, because what we already had in place for Ryan, a trust set up, and we always visit that back to make sure the persons who we have designated to be, who would be oversee and take care of him, is still interested. If there's any things that we need to update, but the power of attorney focused basically on his health, because of his sickle cell disease and the crisis that he was having early on with the disease.
And one of the things I encourage you to take a look at, for the person who asked this question in the audience, is you can see a similar kind of form that was like used in Ryan's case by Quality Trust, posted on supporteddecisionmaking.org under model forms. And you'll see that it lays out specifically when it triggers, what happens until it triggers, so how Ryan is supported up until then, and then after it triggers, a continuing obligation on the part of the agents to still be consulting with Ryan. And so I really encourage you to take a look at supporteddecisionmaking.org's website for that, and I'll try to put it on the chat box shortly. So another question we got is actually for all the panelists. How would you suggest approaching reluctant parent family guardians to invite their interest in this wonderful alternative? So Susie talked a little bit about that, but Debbie and Michael, what do you think?
So one thing that I think is really helpful, and certainly when I've done presentations to parents and family members, is first of all that explaining how it works so that people really understand it, because it is so new, but also explaining that it's actually a lot faster than a guardianship. You can enter into a supported decision-making agreement at the pace that the person wants, and you don't have to wait around for all sorts of procedures. And a lot of times what I've noticed, especially when you have youth who are aging out of special education, parents feel really pressured to rush to get a guardianship because their child is about to turn 18, and they're rushing and they're really worried they're gonna not, what's gonna happen. And so explaining that there's these alternatives, and that there isn't this necessarily have to be this rush, and that it's a lot easier process than a guardianship. It also, frankly, doesn't cost the money that a guardianship does. And sometimes that in itself is enough to get people to start thinking about it.
What about you, Michael?
I just would add to that. I think the sooner families are aware of this option, the more they can not reach this crisis when the person's reaching a certain age where there's pressure to take out guardianship. This is something that should be discussed when the child's quite young with the parent. And sometimes that's best done by other parents who saw the wisdom of avoiding guardianship and can serve in a sense as a mentor and a role model for these parents who are still finding their feet with these issues. I think leaving the discussion till a certain age, like 18 or something, really makes it much harder. You've got to get a lot settled in a short period of time with the pressure of from many quarters of saying you need guardianship when you don't. So I think education with families earlier is a big help to sort out this issue.
That leads really well to another Q&A that we got. Question, Susie, what could we do better in K through 12 education in terms of helping parents, families to understand their options in this and other areas?
For me, I've always found that trying to get myself educated about the matter and always looking for support, because you realize you're not the only parent out there. There's always somebody going through the same experience. So it's always good to educate yourself on the subject matter. Always look to see what other parents are going through, because you'll be surprised what support that other parent you can give each other to assist each other.
I get this question a lot too, and I would ask the other panelists to weigh in as well. I think, Michael alluded to it, that I think a lot of these conversations happen at the quote unquote transfer of rights phase. That's when we first start to talk about decision making, rather than really realizing, as Michael said, that decision making builds over time, and you should be starting these conversations far earlier. Questions about self-advocacy and questions about how to incorporate decision making into special education programming and discussions, so that it's not suddenly like you're falling off a cliff when you turn 18. And I think that takes a lot of advocacy, at least in my experience. Deborah, do you have anything you want to add to that?
Yeah, I would agree. I think that, incorporating those discussions at IEP meetings and, including the student as early as possible. I realize that in some states, transition planning starts at age 16, but there are some states that are starting earlier, but really transition planning should start much earlier. And I think there's nothing to prevent a school district from doing that. And I would really encourage that, so that those, that planning and the input from the student can be ongoing, and so that it isn't then some crisis when the child turns 18.
Thank you so much. So I know we have about 2 minutes or 3 minutes left in our panel. If you have any questions, please put them in the Q&A. Oh, here's a question. Is there training for people with disabilities around supported decisions? We also need a way to learn about it. So have people heard about certain kind of supported decision-making kinds of trainings for people with disabilities? Michael, how have you addressed this kind of question in your pilots?
I think, again, it's there should be some kind of training available to people on what is supported decision making, why it's important, how do you start, what are the problems in terms of practicing it. Otherwise, we just dump people into the deep end on this issue, and it's best done when you're not in a crisis. It's much better to sort these things through in a kind of organized educational process. And I think this should be directed at people with disabilities themselves or others and their families more so than anybody else, because that gives them a certain kind of empowerment in dealing with the various systems that are trying to persuade them to do other things. So in this sense, I'd start with family advocacy type groups and self-advocacy type groups and direct training on this subject to them, and particularly before they're in a crisis about it.
Thank you. So we have another question along those lines. How can self-advocates start educating people in schools about supported decision-making and the capabilities of people with disabilities? People in school have some low expectations. Susie, what do you think? How, I know Project Action, which is the self-advocacy group that you referenced in the conversations, does a lot of kind of peer support. How do you think that peer support could happen in schools?
Well, we were always involved with the PTA, but we also try to keep abreast as to what's going on in the community. We try to learn about different things. And like I said, being a part of the PTA, we would always have suggestions when they would ask about what do you want to talk about for the upcoming school year. And we would try to gear some of the things, especially when it came to advocacy, because we were learning ourselves as a parent with a child with a disability. Like I said, we really had to educate ourselves. And this happened at living in the District of Columbia. There's every national organization here. Back then we went to the Yellow Pages. Now you go online. And just really researching and finding what does your community have to offer, and bring it to the table. At your school, be involved in your school and tell them these are some of the things you want to present it to your PTA and say, we like to really bring these topics up because it's helping us to evolve as a community, and it's helping our children to learn and to grow. So you just really have to get out there, look up the research and present it to the school, find out what's in your community. We're lucky to have Quality Trust in Washington, D.C., but there's a lot of other community organizations that also are learning about supportive decision making. And we try to go out and speak anytime that we're asked to tell our story, to share it with other people, to let them know where they can go, if anything that we know of in the community. And we're always open to be supportive of other parents.
Thank you so much. I really appreciate it. We've reached our end time. I've really appreciated the wonderful insights from each and one of these panel members and the great questions that came in, which were terrific. We want to further this kind of discussion, and I really encourage you to reach out to the panelists if you have questions after the presentation. Thank you so much.